Hey guys. How we doing today? Anyone see me on Facebook? Oh, thanks. Thank you. I said I'd go with a Simpson shirt today. I'm going with a Simpson shirt today. I'm just waiting for the YouTube stream to kick in. I'm getting a little spinning wheel that's saying going live, but it's not quite live yet, I don't think. So bear with me 1 second, folks. I'm just, I've got like 4 monitors open in front of me in my home office. So let's see if I can get YouTube working. Bear with me 1 second. Whoops. Uh-oh. Come on, YouTube, don't fail me. Let's see. Uh-oh. Well, Facebook's working, we know that. I'm going to try YouTube. I'm going to try one more thing on YouTube. I don't want to hold this up too long. Whoops. Someone just asked, on Facebook, is there an advantage to watching YouTube versus Facebook? No, just two different options. But it might just be one different option. Let's see. Hopefully this works. Try one more time. Come on, Facebook. Come on, YouTube. All right, folks. I'm going to give it maybe 1 more minute to work on YouTube. If it doesn't go, I'm going to end up posting this on YouTube anyway. So they're just not going to get to participate live. That's at least live on YouTube. So I apologize for that, YouTube. All right. Well, I want to get started. If YouTube eventually goes live, well, then they'll get us midstream. So thank you everyone for showing up today. Yeah, Barbara Wells, shout out. The tech is killing us all. Shout out to you, by the way, for emailing me this morning before today's blog post went up about the intermittent leave addition to the DOL guidance. I snuck that into the blog post, which was nice. But we have some other guidance, which I wasn't able to sneak into today's blog post, which I'll go over with you. But first, I want to thank everyone for showing up today. Pardon my pasty complexion. I haven't been outside in, days. Little less hair, a little more gray, pasty skin. I guess it's all the life of an employment lawyer, or in your case, not just employment lawyers, but human resources as well. I apologize. I tried to work out the last-minute arrangements with Taylor Swift and Bowser from Sha Na Na. We weren't able to come to an agreement, so I don't believe they are participating today. I'm sorry about that. What can you do? I also, for folks that are here for the first time, someone wrote, what is outside exactly? For folks that are here for the first time or maybe came here on the recommendation of a friend, I want to tell you a little bit about myself. My name is Eric Meyer. I am an employment lawyer. I work for a law firm called Fisher Broyles. You can check us out at fisherbroyles.com. I also have this blog called The Employer Handbook, theemployerhandbook.com. If you haven't already checked it out, please do so. I think it's pretty good. You can sign up for free daily email updates. And if you don't want to get the email, you can just go to the website and check it out anyway. Today, before I get into any legal stuff, I want to remember to give a disclaimer at the outset. The last couple times I've been giving a disclaimer about 30 minutes into the recording, or to the live chat, I should say. Let's do a disclaimer at the outset. I am a lawyer. I am an employment lawyer, but I'm not your employment lawyer, okay? I'm giving advice today, but it's not legal advice. I assume that all of your questions are hypothetical, and you're asking for a friend. So nothing I say here creates attorney-client privilege. Nothing I say here should be taken as specific legal advice for you. If you need specific legal advice, don't be stupid. Don't rely upon some guy who's giving a Facebook chat, right? Call your lawyer, okay? That's what they're there for. All right, let's get started. So, I got a lot of questions from folks, and I wanted to kind of separate them into different categories, all right? So, first category is questions that the DOL did not answer in the guidance that was released really late last night, that I started pouring through furiously at about 7:30 this morning. So some of the questions I got that are addressed in the guidance, which I'm going to go through right now, are how to disseminate the poster, the NLRB rights poster. NLRB. That's how much sleep I've gotten this week. The DOL rights poster. Questions about intermittent and reduced leave schedules. I'll address that. What does the ability or inability to work mean? The Families First Coronavirus Response Act speaks in terms of the ability to work or inability to work. What does that really mean? We'll address that today. We'll talk about what kind of documentation you should be asking your employees for, not just for your own purposes, but also for purposes of the IRS. When you're asking for those tax credits later on, you're going to need to provide some documentation, okay? Next group of questions I got was, what about this waiver we keep hearing about? If we're 50 and under employees, we've been told we can apply for a waiver. Oh yeah, hold on. I'm going to put a note here on the YouTube. Yeah, we're having technical. Sorry, folks, on YouTube, bear with me. On Facebook, bear with me 1 second. Okay. Sorry, I'm directing people over from YouTube over to Facebook, and hopefully we can add some eyes over here. For folks that are just joining us from YouTube, I'll do the introduction again real quickly. Thank you for joining us. My name is Eric Meyer. We're just getting started. You really haven't missed anything. We are talking about some of the questions the DOL guidance has answered, and we're talking about disseminating the poster. We're talking about intermittent and reduced leave schedules, intermittent leave, the ability to work. What does that mean? Documentation for leave and tax credits. How do you apply for a waiver if you have fewer than 50 employees? And what about full-time employees that work a 35-hour work week? Statute says 80 hours, you get paid 80 hours. But what if you work a 35-hour work week? Does that give the employer the opportunity to short you by 5 hours a week? I think that's addressed in the guidance. It might not be the answer that everyone wants to hear. And then we'll talk a little bit about healthcare premiums. That's addressed in the guidance. So let's just blast through the guidance real quickly. Not all of it, but I want to highlight some of the items that are new, that were issued overnight from the Department of Labor. And let's see if I can summarize this for you pretty quickly. So one of the questions that the DOL answers is, may I take 80 hours of paid sick leave for my self-quarantine and then another amount of paid sick leave for another reason provided under the Emergency Paid Sick Leave Act? And the answer there is no. You get 80 hours of paid sick leave, period. Once you use it, you're done, at least under federal law. I would say if you have other PTO in the bank that you haven't used, that your employer provides, certainly you can use that additionally, but you'd have to use that consistent with whatever your employer's policies and procedures are. Next question that was on the DOL's Q&A is, if I am home with my child because his or her school or place of care is closed, child care unavailable, how do I get paid sick leave, expanded family medical leave, or both? You can get both. They interact with one another. They run concurrently. You can get the first 2 weeks paid. You get through paid sick leave at 2/3 of your regular rate of pay, up to $200 a day. And the last 10 weeks would be expanded FMLA at 2/3 of your regular rate of pay, up to $200 a day. So, but one of the questions I also got, which wasn't addressed in the DOL guidance, was what happens if the employee wants to take the first 2 weeks? So those are the paid sick leave weeks, unpaid, right? Not get paid. Then do the last 10 weeks of expanded FMLA, and then save the 2 paid weeks of paid sick leave for another rainy day, so to speak. God forbid, you come down with coronavirus or you're taking care of someone. Could you technically get 14 weeks of leave, 12 paid, 2 unpaid, under the Families First Coronavirus Response Act? I think the answer is technically yes, if your employer allows it. What I've been telling employers is that the first 2 weeks should be paid, right? And then if the employee doesn't elect for payment to have the payment under the paid sick leave, that you provide the paid sick leave payment for the first 2 weeks. Now, maybe I'm wrong about that. Maybe you can get 14 weeks, but I don't think that is the intent of the law. I think the intent of the law is to provide the 12 weeks, or 2 paid, and then 12 under the expanded FMLA, 2 of which run concurrently with the paid sick leave. Other questions that the DOL addressed that were popular, that were in my email box. Can my employer deny me paid sick leave if my employer gave me paid leave for a reason identified in the Emergency Paid Sick Leave Act before it goes into effect on April 1? So retroactivity, there is no retroactivity. No, your employer cannot deny that to you. Is all leave under the FMLA now paid leave? The answer is no. Only this particular type of leave that we're talking about for caring for a child who is home from school. Let's see. Here's another question that was answered before the Q&A, the updated Q&A from the DOL, but I'll repeat it. It bears repeating. I think I brought this up in my blog post today, but it bears repeating. Here's the question. How do I know whether I have been employed for at least 30 calendar days by the employer for purposes of expanded family and medical leave? And the answer is you are considered to have been employed by your employer for at least 30 calendar days if your employer had you on its payroll for the 30 calendar days immediately prior to the day your leave would begin. So for example, if you want to take leave on April 1st, when the law takes effect, you would need to have been on your employer's payroll on March 2nd. But if you're working for the company as a temporary employee and the company subsequently hires you on a full-time basis, you can count that. If you were previously working for the employer, I think it's the CARES Act. What does it say? It says I should have this up in front of me. I apologize. I don't have it memorized. Let me see if I can find that quickly. My little CARES Act guidance here. Where is it? Oh, I don't have it at my fingertips. I apologize. I have so much paper on my desk. I'll come back at that in a second. But basically, if you were on the roster for 30 days before, recently before, laid off and then come back, you've got the 30 days under your belt. I'm saying that inartfully and not quite accurately, but that's basically the gist of it. Okay. Question is, what records do I need to keep? What should I require my employee to provide in order to document the paid sick leave or the expanded family medical leave? All right. So this is important. And here's what the DOL says. The DOL says that if one of your employees takes paid sick leave under the Emergency Paid Sick Leave Act, you must, not may, but you must require your employee to provide you with appropriate documentation in support of the reason for leave. And here's what needs to be on that documentation. You need the employee's name. You need the qualifying reason for the leave, a statement that the employee is unable to work, including telework, for that reason, and the dates for which leave is requested. Okay, so four-ish items there. Documentation for the reason for the leave will also be necessary, such as the source of any quarantine or isolation order, or the name of the healthcare provider who has advised you to self-quarantine. So the DOL gives an example. This documentation may include a copy of the federal, state, or local quarantine or isolation order related to COVID-19, applicable to the employee, or written documentation by a healthcare provider advising the employee to self-quarantine due to concerns related to COVID-19. Why do you need this stuff? Again, because if you want to get the tax credits, you have to produce documentation to the IRS that you weren't allowing employees to take off for any reason, but rather you were giving them time off for paid sick leave or the expanded FMLA. So make sure you're keeping that documentation, all right? This is something that you guys should be developing either on your own or better yet with the help of an employment lawyer. Have this documentation ready. You should have a Families First Coronavirus Response Act policy in place by April 1st. But in addition to that, you're going to need some paperwork that your employees can fill out, even if they fill it out online, because very few people are coming into the office. But have it ready for them to fill out so that you can document the leave, not just for yourself, but also later on for the IRS when you're trying to get those tax credits, okay? Let's see. Here's a question that the DOL has answered, and this was a common question that came in to the email. When am I able to telework under the Families First Coronavirus Response Act? And the answer is you may telework when your employer permits or allows you to perform work while you are at home or at a location other than your normal workplace. Telework is work for which normal wages must be paid and is not compensated under the paid leave provisions of the Families First Coronavirus Response Act. So, I telework every day. My firm is the largest distributed law firm, cloud-based law firm in the world. So I telework every day. This is nothing new for me other than having 4 kids at home who I try and ignore. That's cruel. Who I try not to let bug me. That's still cruel. Who I love adoringly. And give them all the attention I can while trying to put out the many fires that employers have as a result of the state of play that society has seen fit to deal us. But that's basically the definition of telework before I went on that weird tangent there. What does it mean to be able to work, including telework, for COVID-19 related reasons? And it means, so unable to work or telework means you are unable to work if your employer has work for you and one of the COVID-19 qualifying reasons set forth in the FFCRA prevents you from being able to work. So the most common example that we're seeing now is employer says, okay, telework, employee has kids that are at home because their school is closed and they have to care for their kids. Otherwise the kids wouldn't have any supervision whatsoever. That is what we're talking about here. That is an inability to telework. If you can't multitask and do both, and I'm not suggesting that you should, but if you can't multitask and do both, then you can take the paid sick leave and the expanded FMLA leave under the Families First Coronavirus Response Act. Next question, if I am or become unable to telework, am I entitled to paid sick leave or expanded family medical leave? And the answer is, if your employer permits teleworking, allows you to work from home and you're unable to do it, then yeah, of course, you can take the expanded Family Medical Act leave, you can take the paid sick leave. Similarly, if you are unable to perform these teleworking tasks because you're required to take care of your child, then you are entitled to the FMLA leave, the expanded FMLA. Okay. So now this next section of questions that the DOL has answered was a very common one. And by the way, I a lot of this I am reading, trying not to read verbatim. I'm trying to summarize some of it. A lot of what I'm going from right now is available on the DOL's website at dol.gov. So do check this out. Either you don't have to do it right now, you don't have to read along with me, or as I paraphrase, but check it out afterwards. And I'll put links. I think I've done so already, but I'll put links in a blog post on Monday with links to the recording of this live chat. Again, sorry for folks who are on YouTube. I apologize if this isn't working. We'll try and get the kinks worked out. But we'll put links to this. Intermittent leave. So here's the deal on intermittent leave. Can you take it under the Families First Coronavirus Response Act? It depends. There's my first it depends of the day. I'm a lawyer. What can I say? I get at least 10 more of them. It depends on whether the employer is going to allow it, okay? So it needs to be an agreement between employer and employee to permit it. So if the employee says, look, I have a spouse at home with me and my spouse can watch our children for a few hours during the day, but then I have to take over and watch the kids while she works. So she'll work and then I'll work and then I'll work and then he'll work and whatever. That's effectively a reduced leave work schedule or intermittent leave. If your employer says, sorry, no dice, we have work for you to do and you are not doing it, then you take the full day. You take either the full day off. Let me just say full day off. You take paid sick leave and intermittent. You take paid sick leave and expanded FMLA for the full day, okay, or you don't get it at all, unless the employer agrees that you can do the intermittent leave. I don't see any real downside to allowing the employee to do the leave intermittently because at the end of the day, you're going to get a 100% tax credit against Social Security taxes if you're the employer. You're making the employee a little less unhappy given a really crappy situation. So please be flexible and try and meet the needs of your employees just like your employees are trying to meet the business's needs. So consider allowing your employees to work, take intermittent, not just expanded FMLA, but paid sick leave. You can do both. Okay. Here's another round of questions that I got from readers of the blog. Eric, what's going on with these furloughs? What about a furlough? Do we have to provide leave for a furlough? What about a furlough? What is a furlough? What about a layoff? What about a reduction in force? But what about a furlough? Okay. Let's resolve furloughs once and for all. Okay. If the employer, well, actually, I'm gonna keep you waiting for a second on furloughs. Okay, let's lead up to furloughs. Let's build up the suspense. If your company has closed a work site before the law takes effect on April 1st, you do not need to provide paid sick leave or emergency FMLA under the Families First Coronavirus Response Act. Let me repeat that. If your workplace is closed for any reason, before any COVID-19 related reason, right? Either the state has ordered you closed or you've decided that you're just not getting enough business, so you've shut it down. You do not have to provide PSL or expanded FMLA, all right? Period. What if you shut down? What if you shut down after April 1st? Same answer. You do not need to provide paid sick leave or expanded FMLA leave if you shut down after April 1st and there's no work for employees to do, okay? Now, what happens if after April 1st, an employee goes out on paid sick leave? So let's say April 2nd, an employee goes out on paid sick leave. April 10th, while the employee is out on paid sick leave, the employer closes its doors and decides to close the business for a few weeks or a couple months. That unfortunate situation. In that situation, you would provide the paid sick leave for April 2nd through the time that the company has closed its doors, okay? And then on April 10th, and then after April 10th, you have no further obligation to provide the paid sick leave. You would have no further obligation to provide any emergency or expanded or emergency FMLA leave under the Families First Coronavirus Response Act. All right? Now, let's get to the furlough. All right? Here's the question that was asked of the DOL. If my employer is open but furloughs me on or after April 1, which is the effective date of the act, can I receive paid sick leave or expanded Family and Medical Leave Act leave? All right, raise your hand or signify by giving a thumbs up on Facebook. How many folks think yes? Yes, you have to provide paid sick leave or expanded family medical leave if you furlough someone after April 1st. I'm not seeing any thumbs up. How many people think, oh, I saw one? What are you guys all sure? Where is the I don't know emoji? Oh, I see a couple. Oh, I see more. Okay. Oh, I see a lot. Oh, a lot of people think you're going to have to provide. A lot of people think yes. Wow, it's still coming. All right. Let's change emojis. Let's say use the heart emoji, use the love emoji if you think that if you don't have to provide the paid sick leave or expanded FMLA to someone you furlough after April 1st. So someone gets furloughed, you don't have to provide them. If you think you don't have to provide them, use the heart emoji, or you can use the angry emoji. Yeah, I'm seeing a lot more hearts than I did thumbs up, and that's because the hearts have it. You do not have to provide paid sick leave. Let me read verbatim from what the DOL says. Question again. If my employer is open but furloughs me on or after April 1st, 2020, which is the effective date of the FFCRA, can I receive paid sick leave or expanded family medical leave? Answer. Who said it depends? Get the heck out of here. There's no it depends. No. You can't receive the paid sick leave or the expanded family medical leave. If your employer furloughs you because it does not have enough work or business for you, you are not entitled to then take paid sick leave or expanded family and medical leave. However, you may be eligible for unemployment insurance benefits. You should contact your state workforce agency or state unemployment insurance office for specific questions about your eligibility. For additional information, please refer to, and it says go to careeronestop.org. So the person that says it depends. Here's why you can't, as an employer, provide those forms of leave. Because you're not going to get any tax credits for them. All right? If you provided them, it's on you. It's on you. You can't deduct it from the employee's bank. It's literally giving away, and you can do it if you want to. If you are that employee friendly, if you have the liquidity, you can create additional forms and banks of paid time off to provide to employees in those situations. But you can't shoehorn that into the act because you're not going to get those tax credits. Great question. This is where I'm headed next. What about part-time or reduced hours furlough? You ready? If my employer reduces my scheduled work hours, can I use paid sick leave or expanded family and medical leave for the hours that I am no longer scheduled to work? Answer. No. If your employer reduces your work hours because it does not have work for you to perform. You may not use paid sick leave or expanded family medical leave for the hours you are no longer scheduled to work. This is because you are not prevented from working those hours due to a COVID-19 qualifying reason, even if your reduction in hours was somehow related to COVID-19. Again, same rules apply as I said before. Can you provide forms of leave to those folks? Yes. It just can't be FFCRA leave, right? Not as far as the DOL is concerned, and not as far as the IRS is concerned. You're not going to get those tax credits. Someone says unemployment claim? Absolutely. Let me walk that back. It'll vary from state to state, but in most states that I've seen, your employees, if they're furloughed or have a significant reduction in hours, they should apply for unemployment compensation. Okay, and employers, do them a solid and give them information on how to do that. This is a really crappy situation for everyone. Some states allow the employer to help facilitate the process by filing the application. So do everything that you can for your employees to put money in their pockets. The Senate has passed the CARES Act. There's going to be an extra $600 coming from the feds that are going to go in employees' pockets if they're laid off or can't work, but please steer them in the right direction. Okay? Let me close the loop here and go back to one other question that the DOL addressed. If my employer closes my work site on or after April 1st, but tells me that it will reopen at some time in the future, can I receive paid sick leave or expanded family and medical leave? That's really like a furlough, and the answer is no. Not while the work site is closed. You can't get the expanded FMLA. You can't get the paid sick leave. You also, by the way, you cannot collect unemployment insurance benefits for any time that you are collecting pay for paid sick leave or expanded family medical leave. So it's one or the other. I joked before, and it's a terrible joke, that otherwise employees would get to double dip, and it would be the least tasty double dip ever. It's not like vanilla and cookie dough on the same ice cream cone. It's like, crap and crap. I mean, it's not so great. It's worse than nothing. But employees can't collect both unemployment compensation and paid sick leave at the same time. We're doing what we can, but we're never going to be able to make these folks whole. But certainly employees cannot double dip. If I elect to take paid sick leave for expanded family medical leave, must my employer continue my health coverage? So we got a bunch of questions about that too. If there's what's up with insurance and health coverage when someone goes out on paid sick leave or expanded FMLA. And here's the answer from the DOL. If your employer provides group health coverage that you've elected, you are entitled to continued group health coverage during your expanded family and medical leave on the same terms as if you continue to work. If you are enrolled in family coverage, your employer must maintain. And, looks like I almost lost it. Did I lose you guys there? You still there? Someone tell me if the connection is still good. Can you hear me okay? I got a little note that I might have lost people there. Can you guys still see me? All right, good. Getting some thumbs up. Good. I appreciate that. Shout out to shout out to everyone. Shout out to Verizon Fios for maintaining the bandwidth so that we can stay good during this Facebook live chat. No love though for Facebook for not helping us go live there, but can't make everyone happy. Okay. There's also additional information, I'm not going to get into it now, on the DOL's website about applying for COBRA, and information under, there's some HIPAA information there too. Another question, can I use my employer's pre-existing leave entitlements and my FFCRA paid sick leave and expanded FMLA leave concurrently for the same hours? We've talked about this before on these live chats. Do they run concurrently? And the answer is no. So for example, if I am taking expanded FMLA and I'm in like week 4 and I'm getting paid at that 2/3 pay, maximum of $200 per day, can I ask, does my employer have to provide an additional pay consistent with like our own company's PTO policy? And the answer is no. But if you guys want to work something out with your employees, there's nothing stopping you from doing that. Like as an employer, you can supplement their pay. It's up to you. Just know that if you do that, that the government's not going to give you a tax credit for it. So once paid sick leave is in play and an employee's getting paid sick leave, any additional pay you want to give them is on you. It's not on the government's. Bill. So don't try and take a tax credit for that. Okay. Let's see. I think that's pretty much all I wanted to cover under the DOL's guidance. It's updated Q&A. I encourage all of you to check it out. It's at dol.gov. Pretty easy to navigate to. I'm not going to give you the full URL during this chat, but I'll include it in a follow-up blog post. But there are a couple of items before I get to some best practices and some big mistakes that I think employers are making here. There are some other Q&A items that came in. This is a very small stack. I culled this from a much larger stack, but I thought these questions stood out to me as ones that I wanted to answer now, along with kind of a few things thematically that have come up that the DOL hasn't answered yet. One of the questions I got here was about whether an employee would actually be entitled to 14 weeks of leave under the FFCRA, 2 weeks unpaid, 12 weeks paid. I think I said before the answer is probably no, but I don't think there's anything that would stop an employer from allowing that, because really what the government is most concerned about with these tax credits are 12 weeks of paid leave. So if you give 2 weeks of unpaid and then the remaining 12 weeks are paid, I think it's 6 in one hand, half dozen in the other with the government and those tax credits. So I think you could do it. What I've been telling clients is that just run the first 2 weeks of paid sick leave. If it's for taking leave to care for a child that's home from school, give employees the option and encourage them to take that paid sick leave, that PSL under the FFCRA. But if not, I think you could require that they be paid during those weeks. I don't know that there's necessarily for that form of leave in particular. I don't think there's any obligation to let the employee kind of save 2 weeks of paid leave for a rainy day. So that's my read on that. If anyone has a different read, I'm happy to hear it. Again, please don't take anything I'm saying as legal advice. I should probably repeat the disclaimer here. I'm a lawyer. I'm not your lawyer. I consider all of your questions to be hypothetical ones. You're asking for a friend. I'm giving advice. It's not legal advice. Don't get it twisted. We're not creating an attorney-client privilege here, you and I, although some of the people who are on here probably are my clients already. But to the rest of you, you're not my clients. I advise all of you, if you have real legal questions, specific legal questions that you're not asking for a friend, that impact your business, that are really important, don't rely upon me. Go ask your lawyer, okay? Oh, here's a question I got. I liked this one because of the way it was phrased. The business is under 500, is necessary, not even wants to stay open, is supposed to stay open, does not have the ability to have this employee work from home. Employee has no childcare, single parent, daycare closed. So we're under 500, business open, employee can't telework, employee has a child, but no childcare. This reader says, please, underlined, slowly explain how the business would implement both of these acts for her together. I love that. Please slowly explain. Okay, this one's pretty simple. If the employee is supposed to come into the office and work, there's work available for her, okay? But she has a child at home because school is closed and no other childcare, then this employee can take leave, can enjoy the first 2 weeks of leave paid under the paid sick leave portion of the FFCRA, and the final 10 weeks would be paid under the expanded FMLA portion. Now, I'm assuming that this employee has at least 30 days of service with the employer. Otherwise, the employee isn't entitled to the expanded FMLA. So, 12 weeks total. First 2 weeks are paid at 2/3 of the employee's pay, up to a maximum of $200 per day. Last 10 weeks, same thing, paid 2/3 pay, up to $200 per day. I hope that answers the question. I hope that was slow enough, too. I'm going to save this question for the end. I'll keep you in suspense. If my employee violates this is the one I wanted to save for the end. Sorry about that. Here's a question. We provide a very generous PTO allotment to our employees. 4 weeks at hire, prorated based on start date, and up to 8 weeks for tenured employees. Within this policy, we indicate that if an employee is out on FMLA, PTO hours do not accrue. Can we institute the practice for anyone out on expanded FMLA? Would it be considered punitive and therefore not advisable? Well, if you have an existing policy that says that while you're out on leave, really it should be any form of leave, not just FMLA, but while you're out on leave, period, that PTO does not accrue, you can continue to, I don't see any reason why you can't continue to implement that policy. Now, if you change the policy after April 1 to specify that people that stay home with their kids and don't work aren't able to accrue PTO while they're doing that, that could be viewed as punitive, and that might be discriminatory. So I would advise against that. But if you have an existing policy that applies across the board to any form of paid time off, whereby if you're using it, you don't accrue additional paid time off, paid time hours, I think you can continue to apply that. I like this question. This is from a lawyer in Minnesota. I won't say his name, but he's one of my favorite readers. We correspond back and forth from time to time. Does the employee have to have a coronavirus-related condition for which they are advised to self-quarantine? Or can they have an underlying medical condition? In other words, a heart condition, cancer survivor, pregnancy, etc., for which their medical provider advised them not to work for a high-risk employer, such as a hospital, quote unquote, due to concerns related to COVID-19. So does this fit into the paid sick leave definition, which says the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19? I think the answer to that question is yes. I think it's yes. And if the answer is not yes, okay, what you should be thinking about as an employer is the Americans with Disabilities Act and how you can provide a reasonable accommodation to an employee who has a heart condition, a cancer survivor who has a record of a disability, okay, who is immunocompromised. You've got to be thinking about interactive process, right? Good faith dialogue, and can we allow this person to telework rather than have them come into the office? I mean, most people are teleworking anyway, so it's not an issue. But is this a situation where maybe we can allow them to telework? Maybe we can allow them to take unpaid leave from work. But, if you're getting the tax credit anyway, and you have the liquidity, I think it's a close enough call, and it's a good faith read of the statute that you can provide the paid sick leave. I would err on the side of caution there and provide it. Okay, here were my favorite questions. This is the cold-blooded, you can take the lawyer out of the office and you can bring a pandemic into the United States, but you can't take the icy cold water that runs through my veins out of me. If my employee violates a stay-at-home order and has to quarantine as a result, can I take disciplinary action? If I craft my policy correctly, could I enforce disciplinary action? For example, employees who deliberately violate state or federal guidelines resulting in loss of work will be subject to disciplinary action. So, put simply, what if your employees don't follow the social distancing guidelines? What if they, what if they have a block party when the Commonwealth of Pennsylvania, for example, or the state of New Jersey or the state of Michigan or wherever you are that has these stay healthy, stay at home orders? What if someone violates those orders? Can you discipline them? I think the answer is yes. I think the answer is yes, you can. Even in states, now I don't want to get too far ahead of my skis. I'm not licensed to practice in a place like California or Colorado that has off-duty conduct laws, right? But those off-duty conduct laws, as far as I know, and I didn't stay at a Holiday Inn Express last night. That would be disgusting. Nothing against Holiday Inn Express, but I stayed at home. I don't want to leave my house. But I know just enough about these off-duty conduct laws that you can't discipline someone for doing something that's legal on their own time off the clock. What these folks are doing by violating an executive order, that's not legal. So yeah, if you wanted to discipline someone for violating an executive order that says stay at home, yeah, I think technically you could. I don't know how you're going to prove that, but I think technically you could. And here's the final one. I want to fire healthy employees for not reporting to work at our nursing home. I don't even know what to say about that. Here's what I want to say about that. let me walk that back. Comment. I want to fire healthy employees for not reporting to work at our nursing home. I get it. I have clients that are in nursing care that provide visiting nurse services that are healthcare providers, and we have employees who may not want to come to work out of fear of getting the coronavirus or something related to that. Can you fire someone for not coming to work? The answer is probably yes, you can. Okay, but here's where it gets a little bit tricky, and I blogged about this a few days ago. And this is where I think we're going to see an explosion of claims after all of the dust settles down. Okay? And we've already seen a lawsuit filed in Cook County in Illinois, literally alleging something like this. And if an employee, right, claims that if I come to work, I'm going to get sick, okay? So I think, the employee says to the employer, having me come to work is going to create a public health violation. It's against public health mandates. Frankly, maybe it's even against the law because there's a stay-at-home order in my state, all right? Many states have whistleblower laws. And a lot of these whistleblower laws talk about an employee who speaks out to the company, to a supervisor, about a violation of the law, what they perceive to be a violation of the law or some sort of public health mandate. These whistleblower laws many of them say that the employee doesn't have to be right about whether they're complaining about an actual violation of the law. So, for example, if I think that coming to work is going to create a public health hazard, whether it does or not is immaterial. If I have a good faith belief that forcing me to come to work is going to create a public health hazard, or forcing me to come to work would violate a stay-at-home order, okay? If that's my good faith belief, it has to be in good faith, and I'm disciplined for that good faith belief, that protected activity, right? If I'm fired, I may have a whistleblower claim. Now, your mileage may vary. I know in New Jersey, I know how my mileage is going to vary. I'm going to see a lot of these lawsuits. I'm going to end up defending them. In other states, the whistleblower laws aren't as employee friendly. But just be careful about firing employees, even in a healthcare setting, right? It may be something like that lawsuit I referred to earlier, the one in Cook County. The employee alleged that I think it was a nurse or some healthcare provider who alleged that the hospital's masks weren't effective against coronavirus. I don't know if they were N95s that weren't working well, or maybe something less than an N95. And she complained about it, or she alleges she complained about it, and she alleges she was fired for it. So that is the fodder for the whistleblower claim that she has filed. I see that someone has pointed out, hey, Harold Goldner, how you doing? I apologize for not getting back to you on some of your emails. I owe you. I'll give you a phone call later on today so we can catch up. Harold points out that Pennsylvania's whistleblower law is for government employees and public sector only. That's true. Public entities and entities that receive public funding in Pennsylvania are the ones that are covered under Pennsylvania's whistleblower law. New Jersey's is private employers and public employers. And again, your mileage is going to vary depending on the states in which you operate. Couple other questions that were left unanswered by the DOL's Q&A that I wanted to address. What is the general effect of a stay-at-home order that's issued by, let's say, your state, whether it's shelter in place, stay at home, stay healthy, don't go to work? They all have different, kitschy names that try to make them seem less ominous than they really are. Thanks. Robert Small points out that Delaware has same whistleblower rules as Pennsylvania. Thank you. What's with these stay-at-home orders, and do they trigger the first prong under the paid sick leave, which is the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19? I still take the position that these orders do not satisfy that requirement. Why do I take that position? Because you're not stuck in your house if you are subject to one of these orders. Like even in New Jersey, where I am, or if I went across the river to Pennsylvania, nothing's stopping me really from traveling across the river to Pennsylvania. I can go to Walmart. I can go to Target. I can go to Sunoco. I can go to, if any of these companies, by the way, shout out if they want to call me for advice, happy to do that. Anyway, I digress. I can go to the supermarket. I can go to, I can get medical services. I can go for a walk. Am I really quarantined or subject to an isolation order? I don't think so, okay? But as a practical matter, if I can telework, then it's no big deal, right? I still get paid for it. I can't take the leave if I can telework. If I can't telework, more likely than not, I can't go into the office because there's no work for me to do, okay? Maybe the office is closed. Maybe there's been a reduction in hours. And based on the DOL guidance, that controls. I was going to say that trumps, but we're not going to make this political. That controls. So even if I'm subject to, even if I'm technically subject to a quarantine or isolation order, even if you read what's going on, all these state orders as quarantine or isolation orders, if there's no work for me to do because my hours have been reduced, or because the business is closed, or if I can telework, then I don't get the paid sick leave or the expanded FMLA leave. Real quickly, people have been asking me about coordination with other forms of FMLA. You get 12 weeks of FMLA. That's it. Okay? So if you take 6 weeks if you've already taken 6 weeks of FMLA for your own serious health condition, let's say you use the rolling method, 6 weeks of FMLA for your own serious health condition, you only get up to 6 more weeks of FMLA during that 12-month rolling period for expanded FMLA to take care of your child who's home from school. You get 12 weeks total. It's not 12 plus 12, okay? The way the FMLA has been amended, it's still 12 weeks capped. Someone asked me, is there a definition of part-time employee? No, I haven't seen a good definition of part-time employee in this statute. Although there is language in the statute about how you calculate wages for paid sick leave wages for someone who is part-time, so refer to that. What about parents who work for the same employer? I think I addressed this in the last webinar. I shouldn't call this a webinar. Webinar implies slides, and I'm too, I don't want to say I'm too busy. Let's just say I'm too lazy to do slides. I like this better. Parents who work for the same employer, I think they can each take up to 12 weeks of expanded FMLA leave, because the exceptions to that for other forms of FMLA that are already in the FMLA statute, they're specific to caring for a newborn, bonding, fostering a child. Two employees could take 12 weeks of FMLA each. Two, a husband and wife, or spouses, I should say, can take 12 weeks of FMLA each for their own serious health condition. So they can do it, and serious health condition isn't carved out from that. So I think they can do it for expanded FMLA as well. Okay, those were the questions that I had submitted. I see a bunch of other questions that have been fired in here through the chat window. I guess I'll hang around at the end to get to some of those. But what I want to do first, for people who want to get on with their day and don't really want to hang around here all day because we're getting close to the hour mark, I want to talk real quickly about some best practices and some mistakes that I see employers making, okay, with respect to just coronavirus generally, not necessarily the Families First Coronavirus Response Act. Here are some of the mistakes that I'm seeing. Mistake number one is, if you have non-exempt employees that are working from home, employers aren't tracking these hours accurately or don't have systems in place to track these hours accurately. Remember, whether hours are worked in the workplace, telework, any work is work as far as the Fair Labor Standards Act is concerned. So you need to make sure that you have accurate systems in place for tracking these hours, right? And similarly, another mistake is if employees are going to work overtime, teleworking, and you have a rule that says that they need to get permission first from a supervisor before they can do that, please enforce that rule. Have your supervisors, I know it's tough times, but I can't say it any clearer than this, have your supervisors supervise. Make sure that they are enforcing the rules, that you're enforcing the rules, that if folks are going to work more than 40 hours in a work week, even if it's telework, even if it's during this pandemic, that they get the permission first if that's what your policies provide. Because if they work more than 40 in a work week, you're going to have to pay them time and a half if they're non-exempt. Okay? For exempt employees, a mistake I'm seeing is that if you don't want employees working from home, if you don't want them working, period, let's say the office is closed and there's no telework to do, tell them not to work, okay? When an exempt employee works any hours whatsoever in a work week, you owe them their salary for the entire work week, okay? That's the basic rule. Now, you may be able to use vacation days in lieu of certain, you may be able to provide them vacation days and things like that, but where was I? But just, if you don't want folks working and they're exempt, make sure that they're not working, okay? Another mistake I'm seeing that employers make. Don't forget that coronavirus can trigger other original, what I'll call original gangster FMLA rights as well. We're so caught up in this expanded FMLA, right? And paid sick leave. But if someone has coronavirus, okay, diagnosed coronavirus, that's probably a serious health condition, okay? So employers with 50 or more employees, including those that have more than 500 employees that aren't covered by the FFCRA, should be providing FMLA leave under the original FMLA when someone has a serious health condition. Don't forget about that. Also, I don't think many employers are having this problem, but if you're doing reductions in force, if you're doing layoffs now, okay, please do not forget about WARN laws. Not just the federal WARN law. Don't forget about state mini WARN laws. And some cities like Philadelphia has its own mini WARN law. So when you're doing a mass layoff or you're closing a plant location, I'm not going to get into all the nuance of WARN, but usually the trigger is 50 employees. And someone said FMLA Classic. That's what we'll call it. Better than original FMLA. We'll call it FMLA Classic and FMLA Expanded. Think about WARN rights. Usually ordinarily WARN would involve 60 days notice to employees, written notice of getting laid off. What a lot of us employment lawyers are hoping for, clutching our pearls about, is that the notice requirements won't apply here because of unforeseen business circumstances or a natural disaster. But just if you're doing a large layoff, please get assistance from outside counsel. Okay, don't do this on your own. There are WARN issues. There could be ADEA issues, OWBPA issues. So get an employment lawyer involved. And that dovetails into my final mistake. I mean, there are more mistakes, but the big one is please ask for help, okay? If you have questions, call another HR professional, call a lawyer. It's great that you're coming here. I'm glad to provide you this non-legal help, but again, don't rely upon me and what I'm telling you here. I'm just kind of giving you what I'm reading from the DOL's website and what I'm reading from the statute and my educated take on how I think certain laws will be applied. But please get help. This is not the time to do things on your own. Get an employment lawyer to help you out, okay? I will not choose this very moment to plug my law firm and me. I will wait until the very end when I close out this Facebook chat to remind you who I am and who I work for and my blog. Best practices. We talked about it already. Have an FFCRA policy and request form ready to go by April 1st. Consider telework as a reasonable accommodation. We already talked about this with that great question I got from Minnesota about someone who is immunocompromised and the doctor has concerns about their potential exposure to coronavirus. So consider telework and other forms of reasonable accommodation. After all this coronavirus stuff is gone and we can get back to being normal, you may have to repicture telework as a reasonable accommodation, right? Almost everyone's doing it now. You thought maybe a month ago that telework wasn't a reasonable accommodation. Maybe it is now going forward, okay? I'm not saying it is for sure, but have a more open mind about whether telework is a reasonable accommodation for a broader spectrum of employees than it was maybe a month ago, okay? Continue to require advanced approval for overtime. I talked about that. Another thing that we need to be doing is we don't know how long this is going to last. So this is more of an HR thing than an employment lawyer thing, but you got to reimagine performance reviews and how you're going to document performance issues, because when all of this is over, amidst layoffs, whistleblowing, WARN, FLSA violations, FMLA violations, it's going to be lawsuit central, right? Now is the calm before a huge litigation storm that's going to be coming up towards the second half of the year in 2021. We're going to see so much litigation that arises out of COVID-19, okay? And one of the ways that you guys can mitigate risk, that you've always mitigated risk before COVID-19, was good documentation, good performance reviews. All right. Make sure that you have these systems in place, even though everyone's teleworking. Make sure, develop ways, be creative, but develop ways to critique employees, to praise them when they're doing good things, but to document when they're doing not so good things, so that if you have to terminate employment based on performance, that you have it documented. We joke as employment lawyers that if you get before a jury and you don't have any documentation, then whatever you say you did never actually happened. Okay? That's what jurors are going to think. So continue to document. And finally, it's a little bit early. Hopefully it's not too early, but start to think ahead about return to work, right? How are you going to transition folks who are out because the business is closed for a few weeks or because you're having everyone telecommute? How are you going to transition them back into the office? Okay? It's not just from an employment law consideration. Although there are certain ADA issues that'll come up, there are certain FLSA issues that'll come up. But start thinking about that because we've been flying by the seat of our pants for the past week or two. Someone, I think it was over email or maybe it was a comment on LinkedIn, said it kind of feels like we're flying a plane that we're all building at the same time. Yeah, it does. It does feel that way, right? I don't want to say we're rudderless, but we're really flying by the seat of our pants. One area where we don't have to fly by the seat of our pants is with respect to return to work. And we can start to think about the possibilities of bringing people back. We don't know exactly how many people, but we can start to think about options and start to roadmap and game plan for what that's going to be like. I know that's, I get it. That's a little bit back burner, maybe a lot back burner because we're still going through who we're going to lay off, which is sad. It's awful. But don't forget that at some point we're going to be returning to work. Okay. It's a little past 1 o'clock. I'm kind of spent. I think we're going to end this here. I'm going to say thank you to everyone. It's not been the best week. It's not been the best 2 weeks, and your stamina is probably totally waned. Hang in there. I'm hanging in there too. I was completely joking, by the way, in my blog post about no-dose. I haven't had caffeine for a year. This is just natural energy. I'm going off of adrenaline, and I will continue to go off of adrenaline. I'll continue to have client conversations at 11:30 at night. You can call me over the weekend if you need help. I'm happy to do it if you're my client. If you're not my client, I don't want to get into attorney advertising here. I don't want to have my wrist slapped by any bar associations. I will say this. I am an employment lawyer. My name is Eric Meyer. I work for a law firm called Fisher Broyles, FisherBroyles.com. That's FisherBroyles.com. We are the first, the largest, the oldest, cloud-based distributed law firm in the world. So this remote working thing is nothing new to me. It's just, more kids around and probably more emails and more calls. Thank you guys for showing out. Thank you for checking out my blog, theemployerhandbook.com. I love having you guys get the give the comments. I love the emails. Keep them coming. If I can't answer you right away or if I don't answer all your questions, I apologize. But I will, if we like these chats, I'll keep doing them. And eventually I'll find another platform to use with LinkedIn. To use with Facebook. I'm not giving up on YouTube just yet, but we'll see what we can do. All right, folks. Enjoy the rest of your day. Have a great weekend. I will post this on the Facebook page in the next couple of minutes. All right, so you can see the recording. Bye.